This is a video guide for social workers who have received a proposal of accepted disposal from Social Work England's case examiners. This video can help you make an informed decision that's right for you. In this video, and in the case examiner's report, you will hear and see some quite technical language. This reflects the legal nature of Social Work England's rules and regulations, and it is important that we use certain words and phrases to ensure that terminology is correct from a legal perspective. So, what does accepted disposal mean? Accepted disposal is an option for closing fitness to practice cases. It means that the case examiners can close your case without a hearing. The case examiners can propose this option to you along with an outcome that they think is appropriate. Accepted disposal can only proceed if you agree with the decision the case examiners have made, and it's entirely up to you whether you want to take up the offer of an accepted disposal or not. You can reject the proposal and proceed to a hearing if you prefer.
The case examiner's decision. You have received a report from the case examiners. This contains their decision and reasoning. In this section, we'll walk you through the key parts of that decision. For us to conclude your case through the accepted disposal process, you need to accept that your fitness to practice is impaired. But what does that mean? The case examiners review your case. As part of this, they apply a test that we call the realistic prospect test. When we say realistic prospect, we mean that there is a genuine possibility of a finding being made. For the case examiners to be satisfied that there is a realistic prospect of a finding of impairment, they apply a test in 3 stages: facts, grounds, and impairment. First, the case examiners assess the facts of the case. You may see these referred to as allegations in other contexts. The case examiners may decide there is a realistic prospect of a fact being found proven. This means that they have found some evidence to support the concerns raised about your practice. Importantly, the test that the case examiners apply is a lower threshold than the test adjudicators apply at a hearing. With this in mind, if you don't agree with the case examiners that the facts could be found proven, you may wish to request a hearing. For any facts that the case examiners consider could be found proven, they then consider the statutory grounds for impairment. There are 8 statutory grounds. Examples include misconduct and lack of competence or capability. The case examiners assess whether there is a genuine possibility that the facts could meet the threshold for one or more of the statutory grounds. Finally, the case examiners will assess whether there is a genuine possibility that adjudicators could find your fitness to practice impaired. There are 2 elements to this process: the personal element and the public element. For the personal element, the case examiner's focus is on whether there is a risk of repetition. This means that they are trying to understand whether you have insight and whether you have remediated any poor practice or conduct. In health cases, they will explore how you are managing your health. For the public element, the case examiner's focus is on whether it might be in the public interest to make a finding of impairment. For example, if making a finding is necessary to protect the public, safeguard public confidence in the social work profession, or to maintain professional standards for social workers.
If there's a realistic prospect of finding impairment, the case examiners next think about whether a hearing might be necessary in the public interest. The case examiners only offer accepted disposal if they are satisfied that a hearing is not required. Often, the case examiners can resolve a case through accepted disposal and publish the decision on our website. This usually satisfies the public interest. Hearings are a complex process and extend fitness to practice proceedings. This means accepted disposal can offer an earlier resolution. The accepted disposal section of the report will tell you the case examiner's proposed outcome and their reasoning. There are 3 key pieces of information for you to note. 1. The proposed outcome or sanction. 2. The length of time any sanction will remain in place. And 3. The period of time within which you will need to respond to the proposal. The case examiner's decision will explain how they have determined the appropriate sanction. They approach this exercise methodically, starting from the lowest sanction and working up. The decision will also explain the length of time the case examiners think the sanction should be in place. The accepted disposal outcomes the case examiners can propose are no further action, advice, warning order, conditions of practice order, suspension order, or removal order. It's not our role or intention to punish social workers. The case examiners always propose what they consider to be the minimum outcome necessary to protect the public and to serve the wider public interest. The case examiners refer to our sanctions guidance in making this decision. You can find this guidance on our website.
Proposed outcomes. Where accepted disposal has been agreed, the case examiner decision will be published on our website. This means that during the designated period, if somebody were to search for your name on our register, or look for fitness to practice decisions on the website, they would find a link to the case examiner's decision. The first 3 outcomes available to case examiners do not restrict a social worker's right to practice. If the case examiners propose no further action, this means publishing the decision is enough to maintain public confidence. No sanction will be applied. In these cases, the decision will be published on our website for 12 months. Advice means the case examiners will remind you of the professional standards relating to your case. An advice outcome will be published on the website. This will be for either 1, 3, or 5 years depending on the case. In more serious circumstances, the case examiners may issue a warning order. This is a clear sign of disapproval, and a signal that if the behaviour is repeated, you are highly likely to receive a more severe sanction. A warning order will also be published on the website for 1, 3, or 5 years depending on the case. In some cases, the case examiners will decide there needs to be some restriction on your practice. If so, they can propose either a conditions of practice order or a suspension order. A conditions of practice order sets out conditions that you need to comply with. Many of these conditions are standard, meaning we normally use them in all cases. However, you may also find that the case examiners have proposed additional conditions which address the specific circumstances of your case. The case examiners can propose that conditions of practice will stay in place for up to 3 years. A suspension order prohibits you from practicing in England for a set period of time. The case examiners can propose a period of suspension for up to 3 years. The final outcome available to the case examiners is a removal order. This means you are prohibited from practicing social work in England. If you accept this sanction, you can only apply to be restored to the register 5 years from the date that the removal order takes effect. If you return to the register, the previous removal order will remain on your register entry indefinitely. For both conditions and suspensions, adjudicators will review your fitness to practice at a hearing near the end of the time period set by the case examiners. The adjudicators will decide whether you can return to unrestricted practice. They'll consider whether there is any continuing risk of repetition or risk to the public. Where needed, the adjudicators can extend an order or replace it with another order. They can also review an order early. They may do this if new information suggests that conditions or suspension are no longer necessary or proportionate in the circumstances. If you are found fit to practice at a review hearing, a record of the order will remain on your register entry for a further 5 years from the point the order comes to an end. This is unless your case is solely related to health or competence. If you agree to the case examiner's proposal, we will assign a case review officer to your case. They will support you and offer advice throughout the case review process.
Responding to the proposal. It's up to you whether you want to go ahead with accepted disposal. There are 3 options available to you. You can accept the proposal, you can reject the proposal, or you can request amendments to the proposal. If you accept the case examiner's proposal, you are accepting all of the following: the key facts, that your fitness to practice is currently impaired and will be considered impaired for the duration of the proposed sanction, and the terms of the disposal proposed by the case examiners, also known as the sanction. In some cases, the case examiners may propose an accepted disposal outcome, even if you had not accepted current impairment during the investigation. It is up to you, having read their decision, whether you do or do not now accept their conclusions. If you reject the proposal, the case examiners will refer your case to a hearing. You may prefer this option if you disagree with the case examiner's conclusions. At a hearing, your case can be considered afresh. Your rejection will not influence the adjudicator's decision. Although you can request amendments to the proposal, there are limits to what the case examiners can amend. For example, The case examiners can't change the proposed outcome or its duration. The case examiners can make amendments in some specific circumstances. For example, if there is something factually inaccurate within their decision, such as an inaccurate date. You should get in touch as soon as possible if you are not able to respond by the deadline set out in the email. Outline why you need an extension and how much additional time you need. It is up to the case examiners whether to allow an extension. We expect them to avoid unnecessary delays.
Once you've submitted your response, we'll check to ensure that we've received all the required information. We'll then share your response and any comments you've made with the case examiners. They normally reach a final decision within 10 working days. If you have accepted the proposal, the case examiners will review any information you have sent. They will determine whether they are still satisfied that the accepted disposal is in the public interest. If you have rejected the proposal, the case examiners will refer the case to a hearing. The case examiners will agree or reject any requested amendments. Once the case examiners have delivered their final decision, it can't be changed. This means you should think carefully about your response to the case examiner's proposal. Seek further advice if you need to. We hope this video has helped you to better understand the accepted disposal process. Our aim is to support you to make an informed decision. If you have any further questions about accepted disposal, you can contact the Case Examiner Operations team.